Are you concerned that the neonatal care your baby has received may have actually caused harm, either through neglect or error? Hello, I'm Cian O'Carroll, and our team of solicitors here specialises exclusively in medical negligence law. Over the years, we've acted for quite a lot of families with concerns around neonatal care. We've worked recently on very significant cases relating to situations such as a family where a baby with existing serious health concerns was allowed to continue having brain seizures over a period of several weeks, resulting in catastrophic harm. Another family where therapeutic cooling, a necessary therapy to preserve brain tissues following hypoxic ischemic injury, that therapeutic cooling was delayed with catastrophic effect. Another family where the transfer to the National Children's Hospital was both delayed and conducted in the absence of appropriate intubation, thereby resulting in a further worsening of that child's condition. All of these situations, avoidable, resulted in serious, lifelong and life-changing harm, both for the child involved and their family. In each of those situations, when we are instructed, our job is to understand as quickly as possible whether there has been a failure in care, to seek expert opinions from international authorities who can advise our clients accurately and reliably on whether there has been a failure in care and the extent of the harm that has flowed from that failure. And once that's in place, it's then our job to try to get that case progressed as quickly as possible. What's often most important in these situations is progressing the case with great speed so that necessary and expensive therapies and care options can be availed of. That will always be the first priority for the family. But many of these treatment options, in order to maximize the ability of their child, will be available outside the state or through private sources, and therefore money is an option. Nobody wants to take a legal action for money, but people do have to bring legal actions in order to access vital and needed therapies. The courts in such situations can sometimes allow for case management, which allows access to the court process much more quickly. And through that, we have been able to achieve remarkable results for some families within months rather than years. And that can make all the difference. Figuring out whether there has been an actionable failure in care that has caused harm could be regarded as the foundation level in any case. But onto that foundation, we then have to build an understanding of what that injury means in financial terms, talking to care specialists, vocational experts, occupational therapy consultants, looking at assistive technology and other areas of emerging technology that can make a vital difference in your child's development and their future. Because of that, it can be very difficult to understand the full needs of a person at an early stage in life. And obviously, as I've said, we want to try and access necessary damages in order to provide for those therapies at the earliest stage. And so sometimes it's possible to achieve an interim settlement. That allows for you to come back to court multiple times through the life of your child, looking at additional needs and additional available therapies, additional available technologies that we can't even imagine at the moment. So our role as solicitors on your behalf is to use our experience to guide you and advise you, ensure that the very best expert opinions are obtained, and build a solid foundation to any case. Having done so, we then have to ensure that all aspects of your child's needs, now and into the future, are both understood and calculated. And then finally, to try to bring that case as quickly as possible so that those necessary care and therapy options can be accessed quickly and effectively, maximising your child's ability for the future.